Hi, my name is David Fraser. I'm a privacy, internet, and technology lawyer with the Canadian law firm McGinnis Cooper. I also teach internet and media law at the Schulich School of Law at Dalhousie University. The Ontario Divisional Court has just released a decision that should grab the attention of Canadian lawyers who work in cyber incident response. I don't know whether it will be appealed, but the logic is pretty sound. But I expect this whole saga isn't over. In a nutshell, after a significant ransomware incident, LifeLabs was assisted by well-known cybersecurity and forensic consultants for the investigation, remediation, and negotiation with the ransomware bad guys. As required by the relevant privacy laws of those provinces, LifeLabs notified the privacy commissioners of British Columbia and Ontario, and the commissioners themselves started a joint investigation. In connection with their investigation, the commissioners demanded to see the consultants' reports, and LifeLabs claimed that they were privileged. Not surprisingly, the ransomware incident was followed by a number of class action lawsuits that at least were still pending at all material times. In June 2020, the commissioners issued a joint decision finding that LifeLabs had provided insufficient evidence to back up their privilege claims. They were also ordered to hand over the consultants' reports. And so LifeLabs sought judicial review of the order in the Ontario Divisional Court. And the court just released its decision upholding the IPC's order. I'm not sure why it took so long to actually get to a hearing. According to the IPC's decision and the court decision, there were 5 categories of records at issue. The first was the investigation report prepared by the cybersecurity firm hired by LifeLabs, which described how the cyber attack occurred. The second was email correspondence between the cyber intelligence firm, the negotiators, and the cyber attackers after the discovery of the attack by LifeLabs. The third was an internal data analysis prepared by LifeLabs in April of 2020 to describe which individual health information had been affected by the breach and to notify those pursuant to Sections 12 Sub 1 and 12 Sub 2 of the Personal Health Information Protection Act of Ontario. The fourth was a submission from LifeLabs to the commissioners dated May 15, 2020, in response to certain specific questions communicated through legal counsel. And finally, the report of Kevin Fowler of Deloitte LLP, dated June 9, 2020, prepared as part of the representations by LifeLabs and submitted to the commissioners for that purpose. Other than the internal LifeLabs assessments, the records were created by consultants retained by LifeLabs lawyers. The cybersecurity firm was already engaged by LifeLabs to assess the company's security, and it's actually them who discovered the incident in progress. They were instructed to provide their reports on the incident itself, however, to legal counsel. The court reviewed the IPC's privilege decision on a standard of correctness and found that it was, in fact, correct. Now, before getting into the decision, it should be noted that LifeLabs claimed solicitor-client privilege and litigation privilege. They are related and similar, but they're not the same. Solicitor-client privilege protects communications that are made in confidence between a lawyer and their client, or a third party acting on behalf of the client, like a consultant. But in order to be privileged, the communication must be made for the purpose of seeking or giving legal advice, and the parties must have intended that their communication would be confidential. So just because there's a lawyer in the mix doesn't make it privileged. And a third party's involvement, like a consultant retained by the client or the lawyer, that doesn't automatically waive the privilege either. Now, in contrast, litigation privilege is intended to create a zone of privacy within which counsel can prepare draft questions, arguments, strategies, or legal theories in anticipation of litigation and for the purpose of preparing for that litigation. Documents created by others to assist counsel in preparing for litigation can also fit into this category. Notably, the privilege only exists while the litigation is anticipated or ongoing. When you read the decision, you'll see that not much information was provided by LifeLabs, or at least not to the IPC's satisfaction, to demonstrate that the 5 categories of records fit into either solicitor-client privilege or litigation privilege. In large measure, the IPC decided that LifeLabs had to investigate the incident and had an obligation to provide factual information to the IPC. It doesn't look like the IPC was looking for any actual advice given by counsel or anything related to LifeLabs' trial strategy or their ongoing litigation. Ultimately, the decision turned on LifeLabs not providing evidence to the IPC's satisfaction to back up their privilege claims. The main conclusions of the decision, now simplified for a bit, are that 1, facts are not privileged, even if they were collected or compiled by a lawyer. 2, if you have a statutory obligation to investigate and provide information to the regulator, the facts that are discovered in that investigation are not themselves privileged. 3, solicitor-client privilege only protects communications that are made for the purpose of seeking or obtaining legal advice. 4, litigation privilege only protects communications and records that are created for the dominant purpose of preparing for litigation. Now, this is not earth-shattering, but it's a reminder of how the law of privilege works in Canada, particularly in this context. The court emphasized that even if certain communications or documents are privileged, the facts referred to or reflected in those communications may not be privileged if those facts exist independently outside of the privileged context. Facts that have an independent existence outside of solicitor-client privilege communications are not automatically privileged. The court quoted and agreed with paragraph 49 of the IPC's decision. Even if the communication is privileged, the facts referred to or reflected in those communications are not privileged if they exist outside the documents and are relevant and otherwise subject to disclosure. Some facts have a life outside the communication between the lawyer and the client, but have also been communicated within the solicitor-client relationship. Facts that have an independent existence outside of the solicitor-client privilege communications are not privileged. When deciding if such facts are privileged, one must keep one eye on the need to protect the freedom of trust between solicitor and client, and another eye on the potential use of privilege to insulate otherwise discoverable evidence. While privilege is jealously guarded, it must be interpreted to protect only what it is intended to protect and nothing more. The court further clarified that simply depositing a document or providing counsel with a copy of a document does not automatically extend privilege to the original document. The protection of privilege is intended to safeguard the communication between lawyer and client and the adversarial preparation for litigation, not the underlying facts themselves. Therefore, the court concluded that facts concerning the investigation or remediation, even if communicated within a privileged context, may not be privileged if they have an independent existence outside of privileged documents. If an organization has a legal obligation to investigate, remediate, and report to the Privacy Commissioner, interjecting lawyers into the process does not relieve the organization of its obligations to report to the Commissioner. This obligation includes cooperating with the Commissioner's inquiries and providing information necessary for investigations. The court wrote, health information custodians such as LifeLabs cannot defeat these responsibilities by placing facts about privacy breaches inside privileged documents. Although the claims of privilege here were rejected, even if they had been accepted, this would not have defeated the IPC's duty to inquire into the facts about the data breach within the control and knowledge of LifeLabs. The result flows not only from the IPC's statutory mandate, but also from how litigation privilege and solicitor-client privilege function. The court went on to say, thus, the IPC's statutory duty to inquire and LifeLabs' duty to respond does not permit a claim of litigation privilege over facts obtained through its lawyers, even where those facts might also play a role in defending against parallel civil litigation. As Justice Nordheimer wrote in RV Assessment Direct at paragraph 10, quote, the privilege does not protect information that would otherwise have to be disclosed. LifeLabs did not identify any litigation strategy that would have been disclosed in the investigation report because of the privilege decision. Furthermore, the court emphasized that organizations cannot use claims of privilege to shield facts about privacy breaches from the Commissioner. Even if privilege is claimed over certain documents or information, it does not absolve the organization from its duty to cooperate with the Commissioner's investigation and provide relevant facts. The court noted that placing unpalatable facts within privileged documents to avoid investigative orders would undermine the purpose of regulatory oversight and accountability. Just saying something is privileged does not make it privileged. Including a lawyer in a conversation does not make that privileged. Having the lawyer hire the consultant does not automatically make it privileged. The IPC and the court noted that the cybersecurity consulting firm had a prior retainer with LifeLabs related to what it was doing before the incident, during the incident, and afterwards. Simply having the report related to the incident addressed to counsel didn't make that report privileged. The IPC in this regard referred to a U.S. case called In Re Capital One, which LifeLabs said was an error. The court disagreed with LifeLabs and reached actually the same conclusion as the IPC, saying, where a company has a prior retainer with a cybersecurity firm to provide essentially the same services before and after a breach, inserting counsel's name into the contract and stating that the deliverables would be made to counsel on behalf of the client does not render any report prepared subject to the U.S. work product doctrine, which is akin to Canada's litigation privilege. Interesting, the IPC in their March 2020 decision on privilege left the door open for LifeLabs to prove that portions of the records may include information that is still subject to solicitor-client privilege, and invited them to make further submissions. I would have liked to have seen a bit more analysis of what is reasonably contemplated litigation and dominant purpose in the context of the discussion of litigation privilege. The reality is that in the aftermath of an incident like this, litigation is almost certain to follow. Much of the response, or even the approach to the incident response itself, is informed by that likelihood. Many records are created in anticipation of defending litigation, but those records are also useful for, or maybe necessary for, dealing with the commissioner's investigation. Is 50-50 purpose split dominant enough? And some of those records would be created because that's what would be expected of a reasonably prudent company. So is 33-33-33 dominant enough? Should we create different tracks in incident response, assigning certain investigators to the litigation track and others to the commissioner reporting track? Maybe we should consider amending our privacy laws, or evidence acts more generally, to say that the provision of information to a regulator pursuant to a statutory duty does not amount to a waiver of privilege as far as third parties are concerned. I think lawyers who work in this area will have some interesting discussions about this decision. It will be interesting to consider how this affects certain activities that take place outside of the context of dealing with an active incident. For example, I may be retained by a client to provide them with my assessment of whether they are complying with their safeguarding obligations under privacy laws. Often, an engagement like that involves working with expert consultants who examine network security, do penetration testing, and benchmark against best practices. In connection with that, new facts will be uncovered that will be included in my opinion and advice to the client. And at that stage, there's no obligation to assist the privacy regulator with any aspect of that endeavor. The new facts that were uncovered or discovered only for the purpose of providing legal advice. Do they exist independently? I think there are arguments that can be made in both directions regarding whether those newly discovered facts can be privileged. But I think that's probably a discussion for another day. I should add this decision doesn't create any new law about privilege, nor does it put a dizzying spin on privilege law, but it serves as a reminder that you can't throw a blanket of privilege over everything associated with incident response. I also don't think it does away with privilege in connection with incident response. I've provided a lot of advice to a lot of organizations, and I've worked with a lot of outside consultants in contexts like this. I remain confident that my communications with my clients in the context of them seeking my legal advice is untouched by this decision. I hope this has been interesting and useful. I try to put out a new video every few weeks, so if you're interested in this sort of content, please click the like and subscribe buttons. Also, leave a comment if you have any questions or if you have any suggestions for other topics to cover. And of course, feel free to share this with anyone who you think may be interested in hearing about Canadian tech and privacy law. Thanks for tuning in.